Charles Hardin Holley, or as most of us know him, Buddy Holly. He wrote such songs as Not Fade Away, Peggy Sue, Every Day, Listen to Me. Between 1957 and 1958, Buddy Holly and the Crickets had 7 singles in the top 40. He was considered the single most important influence on the Beatles. In 1986, he was inducted into the Rock and Roll Hall of Fame, and in 1996, he was given a Lifetime Achievement Award from the National Academy of Recording Arts and Sciences. Unfortunately, all of these awards are given to him posthumously. He died on February 3rd, 1959 in a tragic plane accident, shortly after taking off flying from Iowa to Moorhead, Minnesota. My name is Gregory Singleton. I'm an estate planning attorney, and we're here to talk estate planning. Today, we're going to look, as part of our Celebrity Estate series, we're going to look at the estate of Buddy Holly. A relatively straightforward estate, but I want to look at this one before we look at one that wasn't quite so straightforward in our next video. But for now, let's focus on Buddy Holly's career. It started essentially in 1956. He had a very short 4-year music career. Or at least rock and roll career. He switched over to, converted to performing rock and roll after opening for none other than Elvis Presley. He died at age 22, and as many 22-year-olds are apt to have, he had no estate planning in place. That meant that he died intestate. When you die testate, it means you die with a will. When you die intestate, it means you die without a will. And when you die without a will that you've drafted yourself, the laws of intestacy for the state in which you reside govern what happens to your stuff. Essentially, the intestacy laws give you a will. Now, when he died, he was a resident of the state of New York, even though he died in Iowa, but he resided in New York at the time of his death, so that is the law that controlled. And under New York intestacy law, everything went to his wife. Now, his wife, Maria Elena Santiago Holley, he had married less than a year prior. But even so, under the laws of New York, she got everything, even though it was less than a year. This is very different than what happens in a divorce, by the way. Now, in every state of which I'm aware, and I haven't done a 50-state survey on this, but in every state of which I'm aware, if you are married and you do not have a will, your spouse is going to get everything unless you have children from a prior relationship, in which case there will be some sort of distribution to both the children and to the spouse. In 1959, the law said everything goes to his spouse. He didn't have children from a prior marriage. His wife was pregnant at the time of his death, but she shortly thereafter had an unfortunate miscarriage. That said, even when they went to court to determine what happened to his estate, the court ruled that his wife got everything as the sole beneficiary. Now, at the time, he'd received about $60,000 in royalties from his music. Inflation adjusted, today that's about $1 million. However, more importantly, his estate included the right to his name, his image, and his related trademark, and several other intellectual properties, including his royalties. His earnings of the estate over the years is estimated to be in the millions. Now, here's the interesting thing. This is why I bring up Buddy Holly. His wife chose to give half of the rights of his music to Buddy Holly's parents. She was not required to do so. There is no law that obligated to her. There was, from what I can tell, no pending litigation of which she was making a settlement to make the litigation go away. There might have been, and we just might not have heard about it, but from what I can tell, on her own accord, she amicably gave half of the rights to his music to his parents. After Buddy Holly died, essentially his wife is known to have done a pretty good job managing his affairs, even though she had no experience in music. Now, I will say there was some litigation between her and Buddy Holly's parents at some point, but they seem to have resolved that. And from what I can tell, they went on to live amicably together. what can we learn from this estate? Usually we're looking at the estates where there's a big problem, people are fighting, and like a trustee is not breaching their fiduciary duties, or personal representative's not doing their job. But here we have a simple case where the individual, the celebrity, died intestate. We distributed things, and then the rest of the family was kind of okay with it. Well, first of all, I want to point out that the laws of intestacy are inflexible. Now, we're lucky, and in this case, the wife, Maria Elena Santiago Holley, gave half of the rights to the music to the parents to make sure that they were taken care of. Probably a wise move to stave off pending litigation, but not necessary. If she chose not to do that, they would have had no right to come and contest the estate. In fact, they didn't contest the estate at all. What if things weren't ideal? What if the parents got nothing and they died destitute? What if Buddy Holley wasn't married to his wife and they were just dating or engaged at that time? She would have gotten nothing and would have had required the parents to give her part of the estate, which they may or may not have done. The big takeaway for this one is Buddy Holley died at the age of 22. And a lot of people think when they come to estate planning, I don't need to worry about estate planning because I'm young. I'm not of retirement age. When I get to age 50 or 60 or 70, then I'll do my will, or then I'll do my trust. But that's not necessarily the right way to go. When you think about estate planning, don't think about what age you are. Think about what is going on in your life. Have you had any major changes? Come into any major assets, bought a house, have a pregnant spouse, pregnant yourself, had a major career change. If you start collecting royalties that are going to go on in perpetuity, that might be a time to determine where they're going to go when you die. It's not about what age you're at. It's about what's going on in your life and what assets you have and what your family situation is. When that determines when you should do your estate planning. We're lucky that in the case of Buddy Holley, his estate turned out okay. His parents were taken care of, his wife was taken care of. It seems to have been amicable. Next time, we're going to look at another celebrity estate where things did not turn out so well, and in fact, led to years and decades of litigation. I hope you liked today's video. If you did like today's video, please hit that like and subscribe button. We do new videos every other Wednesday. If you have questions, leave them in the comments below or send me an email. Otherwise, until next time, this is Gregory Singleton with Signature Law.